Thanks again, John. I do want to make sure that I don't forget how much the county commissioners appreciate Greg, Mike, and all the other guys at ERG. You guys are really integral in helping put this on and taking care of this Raptor Symposium, so we really appreciate that. So our next speaker served 2 terms as Wyoming's 31st governor and currently operates Freudenthal Law Office, LLC in Cheyenne. Mr. Freudenthal was born and raised in Wyoming. He graduated from Amherst College in 1973 and returned to Wyoming to take a position as an economist with the state. Governor Ed Herschler appointed him state planning coordinator in 1975. After graduating from the University of Wyoming College of Law in 1980, Freudenthal opened his own one-person law firm in Cheyenne. The firm grew into a general practice firm representing individuals in business. In 1994, he was appointed U.S. Attorney for the District of Wyoming. Dave and his wife Nancy have 4 children, 5 grandchildren, and live in Cheyenne, Wyoming. Please help me introduce former Governor Dave Freudenthal.
Thank you. I'd rather speak from down here than up there. First of all, thank you for the kind introduction, and thank you for not reading everything that my office sent. I appreciate the opportunity to speak here. I want to preface this a little bit. I understand that there was some concern raised about mixing policy and science, and I understand that. And let me try to explain to you why I think it matters. In my life, I've prosecuted wildlife cases, and our prosecution was very, frankly, science dependent, particularly some of the DNA work and some of the other stuff in order to make the prosecutions work. In my current life, I now defend a number of people who might have had some damaging encounters with eagles, an occasional bat all around the country, including a really strange bat case in Hawaii. And much of this ultimately revolves back into the questions of science and sort of how does it apply. My concern about the Raptors and the Raptor Symposium is that a lot of the stuff we talk about needs to be measured against whether it's decision relevant. That is, does it lead to something that is useful for somebody who has to make a decision? And I distinguish that work from the kind of work I have a son who is a PhD biochemist, which I have no understanding how, my wife and I are both lawyers, how we ended up with him, but he's running a lab at the University of Kansas Medical Center in Kansas City on DNA research. He does very basic research whose purpose is to be one of the early building blocks for people who are going to try to figure out what causes everything from cancer to Alzheimer's to other kinds of diseases. His is a very different kind of science. And the decision relevance of that science is to guide people on the next step. Once you figure out why DNA doesn't heal itself properly, then somebody has to figure out, with that basic science, what's the next step to try to make it work. I think you guys are at a different point, which is you're at a point where this symposium exists because people are confronting decisions. And so this question about science and policy, I think, is really important. And the fact that some kinds of work gets done that is decision relevant and some doesn't, I understand that. But in the context of what we're trying to do here today, which is what do you do, have a policy for raptors, it needs to be informed by science, but ultimately the science needs to be measured against what are the decisions that are going to have to be made. And so I want to talk a minute about the 3 primary statutes that relate to this. Obviously, all of these are federal, Bald and Golden Eagle Act, Endangered Species Act, and then finally the Migratory Bird Treaty Act. Most of the time we'll go on the Migratory Bird Treaty Act because it's the most important. So, next slide, please. You're not exactly Vanna White, but you're doing a nice job. That's it, that's it. The important thing to understand about the Bald and Golden Eagle Protection Act is that it has all of the usual prohibitions about killing, shooting, poisoning, and that. But it also carries with it a definition in the statute. It talks about, or you can't disturb, right? Disturb then is defined in rule as to agitate or bother a bald or golden eagle to a degree that causes or is likely to cause, based on the best scientific information available, injury to the eagle, a decrease in its productivity by substantially interfering with normal breeding, feeding, or sheltering behavior, or nest abandonment, et cetera, et cetera. Okay, why is that important? Because that statute and the regulations reach beyond merely the protection of the species, in the sense of you can't shoot it or poison it or kill it. It reaches to the point of you cannot disturb it in its habitat in a way that causes its either productivity to decline or to abandon the nest. Right? Those kinds of things did not exist, as you'll see when we get to the MBTA. The other thing about the Bald and Golden Eagle Act is it has a permitted take. It has a provision that allows, if you take certain steps, that you can take, that is, you can kill eagles. Then the question is, does it have a habitat obligation? And yes, it does. It has a habitat protection obligation, but it also has a habitat mitigation obligation that's inherent in that statute. Next slide. Endangered Species Act, similar kind of construct. And remember, all of these, the Bald and Golden Eagle Act started in 1940 and then was amended later. ESA was passed in '73. It again has a definition of take, which is broader than what you'll see in the MBTA. Take in their instance includes to harass, harm, pursue. Then it has the standard language of hunt, shoot, wound, kill, trap, or capture. Then they defined harass as an intentional or negligent act or omission, which creates the likelihood of injury, et cetera. Harm is equally broad in terms of its definition. The ESA has a take provision, that is, there are certain conditions under which you can kill or destroy the habitat. And then the question is, does it have a habitat obligation? Yes, it does. Okay. These are very different statutes than what we're going to see in the next slide, which is the MBTA. Right. It's too far away, you can't see it, but here's the gist of it. The MBTA was passed in 1918 for a very specific purpose, which was to deal with essentially the overtake by sportsmen, failure of states to regulate, so we were just decimating all of the migratory bird habitat, or migratory bird population, and it was focused on population, not on habitat. And it was also important at the time that the use of natural feathers in dress, the use of frankly animal skins, including certain kinds of birds, was very much in vogue. So you had a hunting decimation of the population combined with a commercial decimation of the population for purposes having to do with the fashion of the time. There were a series of steps that were taken. There was an earlier act, didn't work out too well. And the thing to remember about this act was when it was passed, the states actually sued to undo it. And it eventually got upheld, not on the Commerce Clause, which is where most of this stuff comes from, but got upheld on the Treaty Clause, because it was necessary to support the treaties that the United States had entered into for the protection of migratory birds from border to border and also into Canada and into Mexico. The important part about this statute is take has a very specific definition, and it means to pursue, hunt, shoot, wound, kill, trap, capture, or collect, or attempt to pursue, hunt, shoot, capture, hunt, shoot, wound, kill, trap, capture, or collect. Okay? Very specific. It doesn't say anything about habitat. So we arrived today at a process where everybody's concerned about the nests. And you'll see in a 2003 United States Fish and Wildlife Service memo where they acknowledge that there is no protection for the nest unless that nest is occupied. That is to say, if it has eggs or live birds in it. And now, somewhere along the line, that sort of is part of their policy, but it's kind of gotten lost. The other question is there any permitted take? There's no take authorized under the MBTA, which is part of the problem. There's no take authorized. It is in many circuits in America, it is viewed as it's always been a statute that is strictly enforced, strictly interpreted. Some of the circuits, though, have said, Unintentional take, that is a take that occurs in connection with an otherwise lawful activity, is not covered by the MBTA. So there's a split in the circuits. We're in the 10th Circuit, and in Wyoming it does matter. In Wyoming it is a strict liability crime. Your take is a take, with one caveat. A take is only considered a take if you were on notice that it was prohibited. That's the Apollo case. The point, what I'm trying to get to is that this is a statute that is currently contested in various parts of the United States. If you go to North Dakota, an unintentional take, that is, if you have a take that occurs in the course of normal business and whose basic purpose isn't to get the bird, it's entirely legal because the courts have ruled that in North Dakota. In Wyoming, because we're in the 10th Circuit, that would not be legal. And that has operative meaning for you when you go ahead. What I want to focus on in the time that remains, and then I'll take questions, what I want to focus on is, I looked at the stuff that you're going to study, and I think there's some questions that have to be asked first. Is there actually, under the MBTA, a requirement that you have these buffer zones? The buffer zones end up being enforced in the following way. They say to you, if you want an APD and you voluntarily agree to these buffers, you'll probably get your APD. Or if you want to get an EIS cleared, you want to get a record of decision, you can fight about those, or you can be like most people have to. They roll over and take those steps in part of the record of decision. And then when you talk to the Fish and Wildlife Service, they say, well, this is all based on the Migratory Bird Treaty Act. Migratory Bird Treaty Act does not protect a nest unless that nest is occupied. So one of the ways that people get around it is we start redefining an occupied nest. It doesn't mean that it's active, that is, that it has birds or eggs in it. It means at any time, depending on who you ask, any time within the last 3 years, any time within the last 5 years, or in some instances, any time within the last 10 years, that nest may have been occupied. And occupied meaning active, that is, it had birds in it. And there's even somebody I know who says that it's really in the eye of the beholder, that they can look at a nest and tell whether it might someday be occupied. It's a gift I don't have. And the reason I bring that up is that when you're trying to set a standard by which industry can operate in an area in which there's no industrial take authorized, which is the Migratory Bird Treaty Act, which covers most of the raptors in question, you end up where we're at right now, which is people say, look, if you're good to us and you do what we want you to do, we'll operate under what is called the Director of OLE, Office of Law Enforcement, has issued a description of how they make prosecutorial decisions. And I know about this because I used it when I was U.S. Attorney. And what they say is if you're a good company or a good person, then we won't turn you in for prosecution to the Department of Justice. And how do they define that? They define that as, have you done an avian protection plan? Have you done this? Have you adhered to that? And yet, when you look at it, that's really just a wink and a nod saying, we'll let you take birds in a statute that doesn't authorize take if you behave. And how do they do that? My argument to you would be, when you start thinking about this raptor question, figure out what decision has to be made. Right? Don't just automatically assume that there has to be a buffer zone. I'm still looking to see where the law says you have to have that. Now, it makes good scientific sense. And particularly if you're in the case where, some companies, put up their own nesting platforms. So they want to protect them and they'll get utilized. But I think that one of the problems that we have is that there's not enough connection between policy and science. So that when you start doing your research, it's tied to some decision that either a policymaker, either somebody at Land Quality or somebody at Fish and Wildlife or somebody at the Wyoming Game and Fish is going to make. So I would try to back up and say, okay, instead of automatically assuming that some things have to be in place, I think the fundamental question is the research you're going to do decision relevant? Does it reach to the point of somebody who has to make a decision about a no or go on whether to issue a permit? And when they say, well, it's the MBTA, I would challenge them to find in the MBTA a requirement that you have a buffer zone for a nest that is not active. All right, having said all that, I know that I better leave because you're a bunch of scientists. And I've offended nearly every principle you have. But I mean, I get into this argument, and I had the same thing because I chaired the science initiative to put together science initiative for the University of Wyoming, which, you know, the good senator reminded me he doesn't like, but we're working on him. And one of the things that came out of it was that the people who are really making a difference in terms of how science ought to look 20 years from now are thinking about what decisions the society has to reach, whether they're large decisions about where to do your research or smaller decisions about how do you set a buffer zone. The best science, in the sense of the science that is valuable and the science that you want to try to focus on, is something that relates to a decision that has to be made. There's another set of people who, obviously funded by largely the National Institute of Health Science Foundation, who do a lot more basic research. But we're past those questions. We need to be talking about what's decision relevant. Okay, so having violated nearly every rule, I'll take questions or I'll turn this over to the next panel. But let me remind you, your next panel is why. So, you know, that I'm posing the same question. Why this research? Yeah.
So my question then.
Tell me who you are.
We're
Tell
good.
everybody who you are.
Oh, I'm Mark Christensen, Campbell County Commissioner. So my question is, it would appear that the MBTA needs to be brought up to date. Now, can that be done by Congress, or is it something that's related to the treaty that would have to be renegotiated with the other countries?
Careful what you ask for. The last administration came up with a really interesting, they wanted to do an MBTA permit program, which we managed, everybody opposed it, we got it killed. Because remember, when you start into this, it covers 800 species and then some. And one of the reasons that it doesn't have a habitat obligation is the case law was originally tested on people who were doing clear cuts and working in forests. There's no way you're going to work in a forest and not end up impacting a nest and birds and the rest of it. So the courts have ruled. So I think there is a way under the current, under that statute, because it says unless and except as permitted by regulation, that you could probably do something by regulation. It would be controversial, because the problem you got is how do you differentiate? I mean, I actually think some of this raptor protection is really a good idea because they're important to the ecosystem, and plus I love watching them. I saw some driving up today, and I mean, it's just, you know, on the other hand, some of the birds that are on the list are so plentiful that you really don't want to end up saying that somebody has to get a permit to go plow a field because they might interrupt the nesting area for somebody who burrows. So I think if you gave it some thought, there's a way to do it, but I would tell you that it will be controversial. But I would argue that it could be done, and that would give guidance. Because remember, where we're at now is company comes in, and the local biologist gets to say, well, I think that nest is alive or it's not, and that's really hard for an operator. Oh yeah, I mean, my view of prosecutorial discretion was very different than my predecessor and different than my successor. And you're going to find that to be the case. And once somebody turns the case, remember the way these cases work, the biological side of fish may discover the incident. It'll be investigated by the U.S. Fish and Wildlife Service Office of Law Enforcement, or probably assisted by the state. Then they'll evaluate it, then they'll decide whether to send it to the Department of Justice. And unfortunately, under this statute, you don't have civil remedies. Under the other two, you've got civil remedies. Under this one, it's all criminal. So you probably end up with, well, I've done some of these on the defense side, which really, because you risk a felony, but at the end of the day, you usually end up pleading to a misdemeanor.
Governor Jim Willicks, Commerce County Commissioner. It should be no surprise, as the policy guy, the first two questions come from policy guys. Mark and I, not scientific guys, but part of the question I have is the buffer zones have become accepted practice, if you will, the norm. How do we unring that bell, though? Is it a policy question, or is it a scientific question to unring the bell on buffer zones, if that's an appropriate direction to go? And I think you're conceding there's places that it is appropriate, but I think the NEF's definition has been a bigger thing. But that's a bell that's pretty hard to unring if it's become the accepted practice. Do you have a thought on that?
I do. What's happened is it's been integrated into all of the resource management plans. But it has language in there that says, you know, usually it's the district, but it could be the field office, can give an exception. And so what you've got is the capacity to do this right. That is to say, in some areas, probably a pretty good idea to have a buffer zone. In others, it's not. It's just that, as you say, it's become almost hard and fast. And if somebody wants an exception, the burden is on them. Whereas the burden ought to be on the person who wants to regulate the activity. And so I think there are some things you could do, but you know, there's a bunch of stuff in these resource management plans that they recently adopted that are really bad. I mean, they're way too open-ended, too much discretion, and the same is true in some of the records of decision. So I'd say it can be done, but it's going to take a discipline. And the problem right now is we're into a period of let's do everything with a blunt instrument. Let's use a machete. The way to do this is to go in with a scalpel and make some quick modifications to how some of the RMP provisions are interpreted. I think it is also fair to revisit the question of what kind of requirement can be imposed by virtue of the MBTA. If you read the U.S. Fish and Wildlife Service stuff, they say, look, we're having you do all of this to help you avoid the risk of a take. And I get that. But at some point, I mean, I get it, but now we have a belt, the suspenders, 3 more suspenders, 5 belts, and a bunch of other stuff. And at some point, you want to say, hold it. Life has some risk. But they're sitting there saying, look, your company doesn't want to be in the newspaper charged with killing a bunch of birds under a criminal statute. So they kind of got you in a hard spot. But I think there are ways to deal with that, but it needs to be done pretty thoughtfully. Because like I say, the question, people really aren't out to not protect these birds, but what they're trying to do is to get the protection to be rational and to recognize, I mean, when I was growing up, I grew up on a place in Zermatt, and we had one of those old Fordson Super Major tractors. That thing just puked diesel. And we had a 2-bottom plow it could barely pull. So when you'd get to the end of the field, particularly when you got up close to the ditch where there were lots of roots, that thing would just die down. Here goes all this smoke and all of this, and sitting in the tree is some raptor watching you, waiting to see if in the process you spook out some little rabbit or some mouse or something, swoop down and get. So, I mean, there's got to be a rational way to do this, and that's where I think this question about the science needs to be more refined so that it can guide a decision that's made with a scalpel instead of with a blunt instrument, which is kind of across the board. We done?
Thank you. Gwen McKee, Great Plains Wildlife Consulting. Good to see you again, Governor. So if I understood what you said, it's your understanding that buffer zones are just arbitrarily assigned as opposed to being developed based on science and understanding how some birds react to disturbance. I mean, I think you could probably find quite a bit of literature demonstrating that buffer zones are based on science. And I think you also could look at all the coal operators in this region and see that a balance has been struck. They work 24/7, every single day of the year. They are heavily regulated, but those regulations and those data requirements are what give them the ability to document tolerance of raptor pairs, and it's been a very successful relationship. So what I'm hearing you say, I'm sure I'm interpreting incorrectly because of my own personal biases, but what I'm hearing you say is we don't need raptor buffers, and I would respectfully disagree with that.
I figured you or somebody would jump to that conclusion. So I said at least 4 or 5 times I get it about needing buffers. I get it about protecting them. I'm not convinced, A, that the statute necessarily requires it. And B, I'm not convinced that this sort of automatic quarter mile, half mile, and the rest of it is necessarily applicable in each individual circumstance. And as I point out, there's this latitude inside like the resource management plans and some of the other stuff. But that latitude gets very seldom used because it's too easy to just to fall back and say, here's the automatic rule. So I'm going to speak very slowly so that you don't get angry. I believe we should protect the Raptors. I'm not sure that the statute supports what is currently being done, and I am not at all convinced that the way we've chosen to implement the science related to buffer zones is necessarily fully practical or rational or necessarily automatically supported in every case by the science. Because you got to remember, the scientists are, with all due respect, they're a lot like lawyers. At the end of the day, some of this stuff is just judgment. And while lawyers are never wrong, we are once in a while. And I think scientists are the same way. So what we call it is better law. And what you guys call it is, well, the newest or better science. And so, you know, let's not get, I would try to stay away from impugning people's motives and start trying to think about this in a practical way about how do we address this in a very careful sense, because I think it can be done. Any other scientists want to take a shot, or did I get enough out there? Yeah.
Okay, now, and it may be more of a discussion. I am a scientist, but I am calling favor with Anadarko Petroleum Corporation. I work with the environmental side of things, so I have a perspective from both sides and how it impacts. And I agree that there's buffer protections and there's the Migratory Bird Treaty Act, no matter if we're in a fee or federal action. Now, federal actions, we're bound, and we have pretty hard and fast rules. And they kind of take the lead from the MBTA. However, on fee, just like the rule is, you're essentially evaluating your risk as an operator because we have no way. It's a recommendation to help you avoid a take. So where is that? It's really a big gray area. How much risk do you want to take? Can you go a quarter mile? What is the species? There's 1,000 nests out there, and probably 10% are going to be used this year. What's your pick? How do you plan? When you have to shut down $1 million operation in the middle to stop for 6 months or 3 months anyway to decide if it's going to be active or not. So from an operator standpoint, you're in a sticky situation, and we start to get real limited in developing the resources in a really efficient and economic way. And we want to do the protections. However, the ruling and how this affects us is pretty risky. You're just deciding how much risk you can take, because there's no upfront either mitigation in place or evaluations that give you some better protections if something did happen, because our intent is not to have a take. However, we can definitely see some really big gaps in the protections for us as an operator, and actually getting some knowns when you go in to develop. It would just help us a lot better if we could understand some mitigation and upfront protections for us. Otherwise, you're going to roll the dice and hope you don't have a violation.
Right. The point you make is a correct one, which is you don't want to be the production manager who calls Houston to say the Federal Fish and Wildlife Service just served a search warrant on us. That's probably not a career advancer. But let me parse that back just a little bit. One of the reasons that there's no mitigation defined is that there's no take. Right? And in the absence of take, nobody's bothered to figure out what mitigation is. So they're slipping mitigation in under the avian protection plans. They don't want to call it mitigation, but they do. And if you do these certain things, then they'll exercise their discretion favorably. And then you get down to this really tricky, this is probably too much lawyer, but this really tricky issue of, do you put the parameters for the exercise of discretion in the ROD or in the individual APD, or do you have kind of a generic one? Because remember, the Fish and Wildlife Service person, right now they're pretty reasonable. We have no idea what they're going to be 3 years from now, when I was U.S. Attorney, we had agents who would indict their mother. We had other agents who were pretty reasonable. And so I think you're right. It's an assessment of risk. And that's why I say we need to think about this from the point of view of research that can help reduce the risk, or that can guide the exercise of discretion, or maybe we go for some kind of rulemaking. Yes.
Hi, Andrea Orabona, Wyoming Game and Fish Department. Nice
Uh-huh.
to see you again. I'm certainly no attorney, so I'm looking at this, the Migratory Bird Treaty Act from the biological standpoint. And my interpretation is that habitat is included in there because when you, and I'm not going to read everything, but
Right.
basically if you take, or all those other things, but if you take a nest or any part or any egg, then that is part of the habitat. Just like in the Bald and Golden Eagle Act, if you take that nest, that's part of the habitat. So I guess I'm interpreting this a little bit
Well,
differently.
if you look at the 2003 guidance from the U.S. Fish and Wildlife Service, it boils down as follows. If the nest has birds and eggs in it, you're right. If the nest is empty, and I go out and cut down the tree, and the nest falls, but I don't possess it or collect it, it's entirely legal. So there's no habitat obligation.
Okay, so I understand that way. So we have about 250 species of non-game birds, since I'm the non-game bird biologist, that breed in the state of Wyoming. Most of those are not raptors, they're songbirds or other species that make a new nest every year. So a lot of this, if that nest goes away, the bird's going to build another one anyway. Raptors, however, are different. So it's trying to fit, a one-stop shop for all these species that have different personalities, different needs, different. So
No, I mean that's exactly why I say, look, this statute was drafted in 1918 for the specific purpose of protecting certain game birds and to prevent the continued destruction of certain birds who had a lovely plume. Nobody thought about the meadowlark. Nobody thought about any number of these other birds that migrate. I mean, if you go back and read the discussion, I mean, it was propelled by these pictures of just this immense slaughter that people did. I mean, you got to remember in those days, the sort of notion of the hunting ethic was, I mean, we were all like wolves. You go kill everything you can. Whereas now, people don't do that. I mean, at least if they do, well, they shouldn't. I mean, if they do, their mother better come back and yell at them. I mean, you just shouldn't do that. But it was a very different time, and this was aimed, and so then, because of the way it was drafted, it just kept expanding, and then they had to deal with it in the context of cutting down forests, because there's no way you could, and so the court found a way to say, look, there's no habitat obligation, and that's pretty well established. Now, if the company cutting down the forest had been saving the nests, you're absolutely right, because they would have collected or possessed. But otherwise, it didn't matter. They could flatten every nest, and it was entirely legal, but they couldn't pick it up. I mean, it's just the way it is. He's giving me the high sign. It's a lot nicer than the hook. And for a Democrat to be in Campbell County and only get a sign and it wasn't one finger in the air, this is good. Thank you very much.